Hello, and welcome to another year of mandatory sexual harassment training. My name is Julie Brooke, and I'm with the law firm of OKGC Law, soon to be Inman and Fitzgibbons, and I will be your trainer today. Now that most of you are probably experts in sexual harassment from attending past training classes, this year I thought what we would do is go through a number of scenarios with using real cases and maybe changing the names a little bit and describing those fact scenarios to see whether you can determine if the conduct described rises to the level of sexual harassment under the law. Now, before we get started, I want to do a few refreshers on the law. First of all, sexual harassment is prohibited by Title VII of the Civil Rights Act of 1964. That's a federal law. Sexual harassment is also prohibited by the Illinois Human Rights Act, which is the Illinois equivalent of Title VII. That's a state law, obviously. And then we have your employer. Every employer in the state of Illinois is mandated to have a sexual harassment policy. So I would encourage you to read through your employer's policy today or while watching the video at some point, so that way you're familiar with the specifics of what your employer requires. We've spoken before about how there's two types of sexual harassment. Quid pro quo, which can only happen when your supervisor harasses you, or a hostile work environment. That's the second type. That's when a coworker or a member of the public harasses you, or it can be when your supervisor harasses you and you don't have what's known as a tangible employment action taken against you. That means like losing your job, being denied a promotion, being denied days off, something of that nature. Basically something that hits you in the pocketbook. Now recall that employers are strictly liable when the harassment is committed by a supervisor and results in a tangible employment action against the employee under federal law. This typically means that the employee loses money due to the harassment by the supervisor. But the harassment by a supervisor doesn't always have to rise to that level for the employer to be held strictly liable. Under Illinois law, it's different. Employers are strictly liable for harassment by a supervisor, even if there's no tangible employment action. So Illinois law is much less forgiving than federal law when the harassment is committed by a supervisor. So case number one. I'm going to change the names on these examples to protect the innocent or the guilty, depending on the case. Selena Gomez is a records clerk with the Baker County Sheriff's Department. Justin Bieber is a sergeant and supervisor in the Sheriff's Department, but not Gomez's supervisor. Selena's job required that she enter warrants and orders of protection in the computer system and take orders of protection to the squad room to be served by the deputies. Selena worked days from 9 a.m. to 5:30 p.m., while Justin was the patrol division sergeant for the second shift from 2:30 p.m. to 11:30 p.m. In November, Justin called Selena at home after an annual cigar dinner attended by sheriff's deputies and asked her to go to Chantilly Lace, a local bar. Justin told her that everyone from the party would be at the bar. Selena agreed to go to the bar with Justin and assumed that Justin's wife, Haley, would be with him, but Justin was alone when he came to pick up Selena. So when they get to the bar, Selena saw only one other person there from the cigar dinner, and she felt uncomfortable and asked Justin to take her home. As she was exiting the car, Justin grabbed her arm and asked for a kiss. Selena refused, telling Justin that he was married and they were just friends. When he would not release her arm, Selena kissed him. She said she felt threatened because Justin would not let go until she kissed him, but Selena doesn't report the incident to the sheriff's department. 1 month later, in December, Justin came to Selena's house unexpectedly to give her a Christmas cup filled with candies. She told him he did not have to do that. Justin left when Selena's ex-husband, The Weeknd, arrived to drop off one of her children. Later that month, Selena attends a party with her friend Taylor Swift. After the party, they go to a bar where Selena sees Justin. Both Selena and Taylor noticed that Justin was glaring at Selena while the women were dancing. Justin asked Selena to dance, and she said no. After 45 minutes, Selena told Taylor she wanted to leave because she felt uncomfortable. That same month, Selena was working in the records office after 5 p.m. when Justin approached her and asked her if she would like to go with him to a motel for the night. And they say chivalry is dead. Be still my heart. I know you're going to be shocked, but Selena said no, reminding him that he was married to Haley and they would always just be friends. On February 5, Selena receives a letter in her office mail dated January 29th that appeared to be on the Illinois Department of Public Health letterhead. It read in part, "Dear Ms. Gomez, this is to inform you that you may have recently been exposed to a communicable or sexually transmitted disease. A confidential source who has tested positive has brought this matter to our attention. To ensure privacy, your file has been assigned a control number of A23759. Please refer to this in future correspondence. It's important that you schedule a screening within the next 7 days. Please contact your local public health office for an appointment. This service is provided at no cost to you." And the letter was signed, "Yours truly, Julie Chelani, MSW Patient Advocate." When Selena read the letter, she became very upset and started shaking. She brought the letter to her supervisor, Lieutenant Sandra Bullock. Selena's crying, she's unable to speak, and Sandra and Selena find out from the Illinois Department of Human Rights that the letter's a forgery. Sandra gives the letter to her supervisor, Chief Deputy Tom Hanks. The Sheriff's Department tells Selena to act normal while they investigated, but deputies approached her saying that they heard she was having an affair with Justin and it went wrong and they heard she has a disease. Chief Hanks orders the Internal Investigation Division to investigate. The Illinois State Police submits a report indicating that Justin's fingerprints were found on the letter. Justin later admits in an interview that he typed the letter on a typewriter in the squad room using old stationery from the Illinois Department of Public Health. Justin said it was just supposed to be a practical joke. What's the harm, right? What does the sheriff's office do? Well, they give him a 4-day suspension without pay and threaten demotion if anything further happens. Selena asked Sheriff Buford T. Justice about the discipline imposed on Justin, and Sheriff Justice told her that he gave Justin as many days as he could without the merit board finding out. He also told Selena not to file a sexual harassment charge, not to go to the media, and not to go near Justin. Selena said she felt degraded, insignificant, and not important because nothing more was done. She was upset because they just did not take this seriously. They just accepted that this was a joke. Prior to the incident, Selena had been seeing a psychiatrist for anxiety and work stress for over 2 years, but because of all that was happening, she began seeing her doctor more frequently. She had to have an increase in the dosage of her medications, and she lost sleep and missed work. Doesn't end there. Selena complains to Chief Hanks that she's unhappy with the way the matter was handled because other employees were talking about the incident, and she also disclosed the prior interactions she had with Justin. So now Chief Hanks kind of has the full picture of this is all that was happening between Selena and Justin Bieber. So what does Tom Hanks do? Chief Hanks, he tells Selena that she should have come forward at the time of the incident so actions could have been taken at that time to stop the behavior. But he still asks her to document the other incidents in writing. She never does. Instead, what does she do? Selena files a charge of discrimination with the Illinois Department of Human Rights against both the Baker County Sheriff's Department and Justin Bieber. Because remember, under the Illinois Human Rights Act, both the entity, the employer, can be named as a respondent or a defendant, as well as individual employees or supervisors. So she brings charges against both of them. Justin's dismissed from the case after settling with her. He pays her off and he gets out. But the sheriff's office is still in the case, and the sheriff's department, basically the claim against them is that Justin retaliated against her because she refused to engage in sexual activity with him, and Justin's actions and the sheriff's department's response created a hostile, embarrassing, and intimidating work environment. And this whole case goes to an administrative hearing before the Illinois Human Rights Commission. And then it goes to the Illinois Supreme Court. Who do you think won the case? Do you think it was Selena Gomez, or do you think that it was, in this particular case, the Sheriff's Department? And just so you know, the name of this woman, Selena Gomez, is actually Donna Felicia, because the case is Sangamon County Sheriff's Department versus the Illinois Human Rights Commission. And in that case, the Illinois Supreme Court looked at whether an employer can be held responsible for sexual harassment by a supervisor who has no authority to affect the terms and conditions of the complaining employee's employment. And this would be regardless of whether the employer knew of the offending conduct and regardless of whether that conduct is quid pro quo sexual harassment or hostile work environment sexual harassment. So literally what the court is being asked to decide is, you have a supervisor who is going rogue and doing bad things, but the complaining employee never notifies the sheriff's office. They have no idea this is happening. Can they still be held liable for it, even if they didn't know? And the Illinois Supreme Court answers the question, yes, you can. Because under the language of the Illinois Human Rights Act, it's a civil rights violation for any employer, employee, agent of any employer, employment agency, or labor organization to engage in sexual harassment, provided that the employer shall be responsible for sexual harassment of the employer's employees by non-employees or non-managerial and non-supervisory employees only if the employer becomes aware of the conduct and fails to take reasonable corrective measures. So, what does that mean? That means that under Illinois law, if the alleged harasser is either a non-employee or a non-managerial employee, the employer can only be held responsible for the harassment if it's aware of the conduct and it fails to take reasonable corrective measures. But if Justin Bieber is a supervisor, the Sheriff's Department is going to be liable for the sexual harassment of Selena, regardless of whether it was aware of the harassment or whether it took measures to put a stop to it. Now, the Sheriff's Office in this case had argued that Justin should not be considered a supervisor under the statute because he had no direct supervisory authority over Selena. But the Illinois Supreme Court rejected that argument, finding that there's no language in the Illinois Human Rights Act that limits the employer's liability based on the harasser's relationship to the victim. In making this decision, the Supreme Court noted that Illinois law is stricter than federal law because under Title VII of the Civil Rights Act of 1964, an employer can only be held strictly liable for a supervisor's harassment if the supervisor had immediate or successively higher authority over the employee, or if the supervisor possessed the authority to directly affect the terms and conditions of the victim's employment. The Sheriff's Department had made another argument. They argued that it would be unfair to hold employers liable because for large corporations, it's almost impossible for them to know what low-level supervisors are doing. The Supreme Court rejected this also, finding that it's not unfair to hold employers responsible for sexual harassment by supervisory employees. Not only are supervisors the public face of the employer, but the employers are in the best position to train supervisors and make them aware of the law prohibiting sexual harassment. Next, the Sheriff's Department also argued that the plaintiff, here this was actually Donna Felicia, failed to establish the elements of a hostile work environment claim. So let's look at how the Illinois Human Rights Act defines sexual harassment. They define it as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Or the third way is such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. So, Under this definition, the law allows an employee to prove sexual harassment by showing either that the conduct substantially interfered with her work performance or that the conduct created an intimidating, hostile, or offensive work environment. In this case, the court found that the supervisor committed a variety of sexually harassing acts that cumulatively constituted a hostile work environment, especially when he drafts this forged letter from the supposed Illinois Department of Public Health that it basically promoted a sexual atmosphere in the sheriff's department generally and in the employee's work life particularly. It communicated, according to the court, humiliating and false allegation of a sexual nature. She and other employees stopped working to deal with this letter, and the sheriff directed department resources towards the investigation and involved an independent law enforcement agency. And the facts also showed that the employee missed work days and sleep because of the incident with the letter, showing that it also interfered with her work performance. Okay, let's move on to case number 2. Eric employee worked for Living the Dream LLC, an oil platform in the Gulf of Mexico. Eric's part of an 8-man crew that drilled for oil. Eric claimed that his male supervisors and male co-workers forcibly subjected him to sex-related humiliating acts, including a physical assault in the shower area and threatening him with rape. Nice co-workers, nice supervisor, right? Eric complains to Living the Dream's safety compliance clerk, who only stated that those supervisors picked on him all the time too and called him a name suggesting homosexuality. So, keys of no help, right? Eric eventually quits. He asks that his pink slip reflect that he voluntarily left due to sexual harassment and verbal abuse. When asked at his deposition why he left the company, Eric stated, "I felt that if I didn't leave my job that I would be raped or forced to have sex," which obviously nobody would want to do that, correct? Easy, right? So Eric filed suit against his employer, claiming a violation of the federal law, Title VII of the Civil Rights Act of 1964, which prohibits discrimination because of sex. The district court, which is the first level, and the appellate court rule in favor of the employer. And they hold that a male has no cause of action under Title VII for harassment by male coworkers. The case goes on to the United States Supreme Court. How do you think the court rules? The Supreme Court reverses, and they find that Title VII does actually protect men from sexual harassment from other men. The case is Ancale versus Sundowner Offshore Services, Inc. from 1998. And basically what the court says is Title VII's prohibition of discrimination because of sex protects men as well as women. The court found that nothing in Title VII necessarily bars a claim of discrimination because of sex, merely because the plaintiff and the defendant or the person charged with acting on behalf of the defendant are of the same sex. In making this ruling, the court rejected decisions from lower courts that held that same-sex sexual harassment could never violate Title VII, and from those that mandated that one prove that the harasser is homosexual and thus presumably motivated by sexual desire. Rather, the court held that harassing conduct need not be motivated by sexual desire to support an inference of discrimination on the basis of sex. So we've talked about this before. You can be working in a hostile work environment because your coworkers hate your guts and tease you and treat you worse all the time, and they're not doing it to people of the other gender. That's going to be actionable under Title VII. So the court was not willing to say that any and all sexually related conversations or acts would violate the law. What the court said is conduct that is not severe or pervasive enough to create an objectively hostile or abusive work environment, an environment that a reasonable person would find hostile or abusive, does not violate the law. And that's because the court does not want juries to mistake ordinary socializing in the workplace, such as male-on-male horseplay or intersexual flirtation, for discriminatory conditions of employment. But again, keep in mind that your own employer's policy can be stricter than federal law, which means that you can be disciplined or even terminated for engaging in this type of conduct at work because it's a violation of your employer's policy, even though it's technically not a violation of Title VII, the federal law. We're going to move on to case number 3. And this one I'm going to use the real names because maybe some of you who are my age or older might remember hearing about this case about 15 years ago. Anuka Brown Sanders was a star women's basketball player at Northwestern University, graduating a year before I started there. She went on to play on the U.S. women's national team before retiring, and in the year 2000, she's hired by the New York Knicks as a marketing executive. In 2002, she's promoted to the position of Senior Vice President of Marketing and Business Operations by the franchise. So it makes her one of the most powerful female Black executives in pro sports in the United States. She held that role for nearly 4 years until January 2006 when she was fired. So what happened in the interim? The Knicks itself, that team, is owned by Madison Square Garden Limited Partnership, which is run by James Dolan. When Brown Sanders first worked there, her supervisor was Stephen Mills, who rose to the position of president of MSG Sports Team Operations. So MSG is Madison Square Garden. 3 years after she's hired, former pro basketball player Isaiah Thomas, some of you might remember him, he's hired as the president of basketball operations for the Knicks in December 2003. Although Thomas doesn't directly supervise Brown Sanders, she's responsible for keeping Thomas informed about business developments related to the team. Starting in 2004, Brown Sanders began having difficulties at work with Thomas as well as Frank Murphy, the senior VP of basketball operations. By 2005, Brown Sanders and Thomas's relationship was increasingly strained because she claims that he would repeatedly hit on her, stating he loved her and requesting that she go off-site with him. He tried to kiss her on the cheek, and when she pulled away, he said, "No love today?" Brown Sanders also had trouble with the Knicks player Stephon Marbury, who openly expressed hostility towards her. Brown Sanders reported Thomas to her boss, Stephen Mills, who was the president of MSG Sports. And Mills responded, "Well, you should be prepared that Isaiah is going to start a rumor about you having an affair with Jeff Nix, another employee in the Knicks office." Brown Sanders, who's married at the time, said, I said, "Steve, is that a threat?" And he said, No, it's not a threat. And she said, "Do I need to find a lawyer?" And he said, "No, you don't need to find a lawyer." And the conversation ends. So let's jump forward to December 2005. Brown Sanders actually did retain a lawyer who meets with Madison Square Garden's attorney and informs them of Brown Sanders' sexual harassment complaint. The company conducts an internal investigation into her allegations, and Thomas denies everything that she's saying and claims that Brown Sanders wanted to be making decisions for him and acted like she was the boss. Ultimately, the investigators recommended that Thomas attend sensitivity training because he occasionally used profanity and raised his voice, as well as one occasion where he actually did admit that he greeted Brown Sanders with a hug and a kiss. The memo found that most of Brown Sanders' allegations were not confirmed, and she exhibited a poor relationship and difficulty interacting with members of management due to different philosophies and management styles, which the investigators believed impacted Brown Sanders' communication skills and overall effectiveness. So the investigators recommended that Brown Sanders should be terminated. So she's fired on January 16, 2006 by MSG Chairman Dolan. Brown Sanders then filed an EEOC complaint and filed suit alleging she was discriminated against on the basis of her sex and terminated in retaliation for her sexual harassment complaint. Thomas held press conferences in response, claiming that she was trying to use him as a pawn for her financial gain and denying her claims. Discovery in the case revealed allegations of a sex romp in an SUV, rampant profane outbursts, the team president ordering a female Garden exec to flirt with the referees before a game, and Marbury's cousin, a Garden employee, telling a female intern, "I bet you that pee for her genitalia looks good." After discovery was completed, neither side moves for summary judgment on the sex discrimination, sexual harassment claims, so you know those are actually going to go to trial. But Brown Sanders, as well as Thomas, moved for partial summary judgment in their favor on the claim that she was retaliated against for complaining of harassment and discrimination. Neither Dolan nor MSG moves for summary judgment. So Title VII states that it shall be an unlawful employment practice for an employer to discriminate against any of his employees because she has opposed any practice made an unlawful employment practice by Title VII, or because she made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under Title VII. So remember that anytime you make a complaint of a hostile work environment or discrimination, or you participate in an investigation brought about by someone else's complaint, you are protected under the law from retaliation. An employer cannot retaliate against you for your complaint or your participation. Brown Sanders moves for summary judgment on the retaliation claim, arguing that Dolan's testimony conclusively establishes that she was fired because of her complaints of sexual harassment. Dolan testified that he personally and unilaterally decided to fire Brown Sanders, and although he was dissatisfied with her performance, he would not have fired her for performance-related reasons, but for her actions in connection to her complaints of discrimination, which he considered to be the last straw that led to her termination. The defendants argued that Brown Sanders was not fired for complaining of sexual harassment, but rather for what Dolan regarded as her bad faith efforts to obstruct the investigation of her complaints by pressuring her subordinates to support her case, and her bad faith efforts to extort money from MSG by deliberately false accusations in which she herself did not believe. Essentially, the defendants argued that Brown Sanders, number one, did not have a good faith belief that she's subjected to sexual harassment, and number two, she's not fired because of her sexual harassment complaint. She's fired instead for a legitimate non-retaliatory reason, which is she is trying to extort this money from the company for her own benefit. The court finds that her retaliation claims would have to go to a jury trial because even though the defendants asserted two seemingly inconsistent reasons for Brown Sanders' termination, a jury would have to decide whether she was retaliated against. So those inconsistent statements were, first, at the EEOC, they said she was terminated because she lacked the interpersonal skills to perform the job effectively and refused to follow MSG's direction. And then the second reason they gave was during depositions after the lawsuit was filed. Dolan repeatedly said that, even though she's not doing a very good job, I wouldn't have fired her for that, but for her conduct during the internal investigation of her sexual harassment complaint. Because Dolan gets upset because she's trying to get other employees to support her, and also he's upset because of this, what he considers an extortion with the settlement demand. So keep in mind that when employers give inconsistent reasons for an employment decision, that can show that they're lying about the real reason for the employment decision, and the case has to go to trial. So ultimately, Brown Sanders' lawsuit is tried to a jury in New York that returns a verdict in her favor of $11.6 million. Yes, you heard that correct, $11.6 million against MSG and Dolan. Of that amount, $6 million was for the hostile work environment caused by Isaiah Thomas. The rest of the verdict was for being terminated in retaliation for her complaints. Interestingly, the jury did not award punitive damages against Thomas. Reportedly, 6 of the 7 jurors voted to assess punitive damages against him, but because they couldn't unanimously agree, they essentially had a hung jury, and the case was going to have to be retried solely on the punitive damage claims against Thomas. Instead, though, at the urging of then NBA Commissioner David Stern, MSG and Brown Saunders later settled all claims, including those against Thomas, for $11.5 million total. So what can we learn from this case? Certainly, creating a hostile work environment for an employee can be very expensive. The higher up that an alleged harasser is in the organization, the less likely a jury will be sympathetic to your denials or rationalization for your behavior. Without question, retaliating against someone for bringing concerns of a hostile work environment to the employer's attention opens an employer up to liability for retaliation. Let's talk about case number 4, and we're back to changing the names on this one. Wendy Worker works part-time between 1985 and 1990 for the City of Sunshine Parks and Recreation Department as an ocean lifeguard while attending college and in the summer. During her employment, her immediate supervisors were Mo, Larry, and Curly. The city operates a public beach that has a small one-story building where the lifeguards and the supervisors work. The building has an office, meeting room, and a single unisex locker with a shower. So the employees are kind of together in this building when they're not actually lifeguarding. Lifeguards work in a paramilitary configuration where they report to lieutenants, including Larry and Curly, and captains who reported to Mo, the chief of the Marine Safety Division. Mo had authority to hire new lifeguards, subject to the approval of higher management, to supervise all aspects of lifeguards' work assignments, to engage in counseling, to deliver oral reprimands, and to make a record of discipline. Larry and Curly later get promoted to captain, and Larry and Curly were responsible for making the lifeguards' daily assignments and for supervising their work and fitness training. Mo was supervised by the recreation superintendent, who reported to the director of Parks and Recreation, Ron Swanson. In 1986, the City of Sunshine adopts a sexual harassment policy and sent it to employees through a memo from the city manager. However, the city never sent the policy to the lifeguards or to their supervisors, so Mo, Larry, and Curly were unaware of the policy. During the time frame that Wendy worked as a lifeguard, there were between 40 to 50 lifeguards employed by the city, and 4 to 6 of them were women. Wendy claimed that Mo repeatedly touched the bodies of female employees without invitation, would put his arm around Wendy with his hand on her rear end, and once made contact with another female lifeguard in a motion for sexual stimulation. Mo often made crudely demeaning references to women generally, and once commented disparagingly on Wendy's shape. During a job interview with a woman he hired as a lifeguard, Mo said that the female lifeguards had sex with their male counterparts and asked whether she would do the same. You can't make this up. Larry behaved similarly to Mo. He once tackled Wendy and remarked that, but for a physical characteristic of hers that he found unattractive, he would readily have sexual relations with her. Another time, Larry pantomimed an act of oral sex. Within earshot of the female lifeguards, Larry made frequent vulgar references to women and sexual matters, commenting on the bodies of female lifeguards and beachgoers, and at least twice told female lifeguards that he would like to engage in sex with them. As an aside, I would think that virtually all women would agree that a guy rating a female's attractiveness and revealing his willingness to have sex with her is not something that women would find flattering. I digress. So Wendy doesn't complain to higher management about Mo or Larry. Although she spoke of their behavior to Curly, she did not regard the discussions as formal complaints to a supervisor, but as conversations with a person she held in high esteem. Other female lifeguards had similar informal talks with Curly, but because Curly did not feel that it was his place to do so, he didn't report the complaints to his supervisor, Mo, or to any other city official. Curly responded to the complaints of one lifeguard by saying, "The city just doesn't care." In April 1990, 2 months before Wendy's resignation, April Lundgate, a former lifeguard, wrote to Chris Traeger, the city's personnel director, complaining that Mo and Larry had harassed her and other female lifeguards. Following an investigation of this complaint, the city found that Mo and Larry had behaved improperly, reprimanded them, and required them to choose between a suspension without pay or the forfeiture of annual leave. Wendy resigned as a lifeguard and filed an EEOC charge and later a Title VII federal lawsuit against the City of Sunshine, as well as Mo and Larry individually under Section 1983 of the Civil Rights Act and Florida state law. Because remember that if you work for a public entity, a public employer, such as a county, a city, a township, school district, anything like that, you can be personally liable and sued under Section 1983 of the Civil Rights Act. So Wendy alleged that Mo and Larry created a sexually hostile atmosphere at the beach by repeatedly subjecting Wendy and other female lifeguards to uninvited and offensive touching by making lewd remarks and by speaking of women in offensive terms. Wendy also claimed in the lawsuit that Mo once said that he would never promote a woman to the rank of lieutenant, and that Larry had said to Wendy, "Date me or clean the toilets for a year." Does anyone think you could say that? No, you can't. Following a bench trial, the district court judge found that the conduct of Mo and Larry was discriminatory harassment sufficiently serious to alter the conditions of Wendy's employment and constitute an abusive working environment. The court also found there were 3 reasons to hold the City of Sunshine liable for the harassment of its supervisory employees. First, the harassment was pervasive enough to support an inference that the city had knowledge or constructive knowledge that it was happening. Second, the city was liable under traditional agency principles because Mo and Larry were acting as its agents when they committed the harassing acts. And 3, Curley's knowledge of the harassment, combined with his inaction, provided a further basis for imputing liability on the city. The Court of Appeals for the 11th Circuit reversed judgment against the city. Although the appellate court agreed that Mo and Larry's conduct was severe and pervasive enough to create an objectively abusive working environment, the appellate court concluded that Mo and Larry were not acting within the scope of their employment when they engaged in the harassment, that they were not aided in their actions by the titles they were given by the city, and that the city had no constructive knowledge of the harassment by virtue of its pervasiveness or Curley's actual knowledge. So the case then gets appealed to the full Court of Appeals, all of the judges in the appellate court, and they adopt the original appellate court's conclusion, but disagreed with some of the reasoning. The case now goes to the United States Supreme Court, and the issue was, under what circumstances should an employer be held responsible for hostile work environment sexual harassment by supervisory employees? So remember, earlier we talked about how it's handled under Illinois law with the case with Sangamon County Sheriff's Office, and now we're talking about federal law under Title VII. And the question is, do you think that the city should be held responsible for Mo and Larry's harassment of Wendy, even though Wendy never complained and the city claims it had no knowledge about Mo and Larry's behavior until April Lundgate complained? Wendy actually wins. In the case of Farragher versus City of Boca Raton, this is a 1998 decision, the United States Supreme Court first addressed the standards for setting forth a hostile work environment. First, Title VII was not meant to be a general civility code. So complaints about ordinary tribulations of the workplace, such as sporadic use of abusive language, gender-related jokes, and occasional teasing are not going to violate the law. Second, the sexually objectionable work environment must be both objectively and subjectively offensive, one that a reasonable person would find hostile or abusive, and one that the victim, in fact, did perceive to be so. Now, we've spoken before about how that subjective component is always going to be met because presumably the employee will talk about how miserable she was from the offensive behavior in the workplace. So the focus of the court's decision is always going to be on that objective component. So to determine whether the work environment is objectively hostile, courts will look at all of the circumstances, including factors such as the frequency of the discriminatory conduct, its severity, whether it's physically threatening or humiliating or a mere offensive utterance, and whether it unreasonably interfered with a person's ability to do their job. The third issue is that when the harassment culminates in tangible results, such as being fired, demoted, or lowering of an employee's salary or suspension with lost pay, the employer will be liable if there was discrimination. So ultimately, the court rules in the Farragher case, as well as its companion case, Burlington Industries versus Ellerth, that what we now know as the Farragher-Ellerth affirmative defense, which is that an employer is strictly liable to an employee under Title VII, the federal law, for an actionable hostile work environment. So it's got to be severe or pervasive, and it has to be based on sex. And that's created by a supervisor with immediate or successively higher authority over the employee when there is a tangible employment action. In contrast, when there's no tangible employment action, you haven't been fired, you haven't been demoted, suspended, you haven't lost any money. So when that happens, there's no tangible employment action, the employer can avoid liability to the employee through the affirmative defense. So the affirmative defense requires the employer to prove two things: that the employer exercised reasonable care to prevent and correct promptly any sexually harassing behavior, and the plaintiff employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer or to avoid harm otherwise. So if you do not let anybody know that you have a problem, then you run the risk that you lose your lawsuit. The court found that proof that an employer had an anti-harassment policy with a complaint procedure is one way to exercise reasonable care to prevent sexually harassing behavior. But in the Ellerth case, the Supreme Court found that the city of Boca Raton could not take advantage of this affirmative defense because even though they had the sexual harassment policy and Ellerth failed to complain up the chain of command, the city never actually made sure that all of the employees knew about it. So if nobody knows that there's a policy, they have no idea what steps they have to take if they want to make a complaint, then you certainly can't penalize them for their failure to do so. And the court also found that officials made no attempt to keep track of the conduct of supervisors like Mo and Larry, and the city's policy did not include any assurance that the harassing supervisors could be bypassed in making the complaints. So what can we learn from the Ellerth case? First, it's important under federal law and specifically required by state law that all employers have policies against sexual harassment with clear reporting mechanisms and an ability to bypass a supervisor who is allegedly harassing the employee. Second, the policy must be given to all employees, and Illinois requires annual training on the law. Third, unlike the Sangamon County case that we spoke about earlier and the fake letter from the Illinois Department of Public Health, an employer's liability for harassment by a supervisor is not as all-encompassing as in Illinois law under the Illinois Human Rights Act. It's a little bit less stringent under federal law. Fourth, when no tangible employment action is taken against an employee, such as that firing, demotion, suspension, an employee must notify a supervisor who has the power to put an end to the harassment of the specifics of your complaint. You should not remain silent no matter how obvious you believe the harassment is and expect that a judge will rule in your favor. You should first give the employer a chance to put an end to the behavior that you find objectionable. We're now going to talk about case number 5. Holly Magdiars and Megan Murray were employed as associate county counselors in St. Charles County, Missouri. So I did not change the names on this one. Essentially, both were lawyers for the county. In 2020, they filed suit against St. Charles County, Missouri, alleging that Chief Todd sexually harassed them. One of Magdiar's claims is that when she was 8.5 months pregnant, Chief Todd introduced her to members of a regional SWAT team and said, "Boys, this is Holly. Get a good look at her and make sure it's not yours." She also alleged that Todd said that the police department was lucky to have such a smart lawyer, but smoking hot doesn't hurt either. Murray's lawsuit says that Todd sent text messages with sexually explicit images, discussed her sex life, and told her to sleep with a rich man to pay for breast implants. One of Todd's texts said, "I see breasts in your future," according to her suit. Now remember that since Chief Todd is sending this to Murray via text message, she presumably saved them and can prove her allegations. So it's going to be really hard for him to deny it when she has the actual proof of the text messages he sent her. Now, the lawsuits further allege that sexual harassment and mistreatment of women was the norm for Todd while he was employed by St. Charles, who engaged in a pattern and practice of subjecting female employees to sexual harassment and/or gender-hostile work environment with impunity. Both lawsuits say the women alerted others to Todd's conduct, including County Executive Steve Ailman and Director of Administration Joan Lakeham, as well as current and former county councilors, but that none put a stop to it. Magdiar's suit also alleged that a former county councilor made demeaning comments about women and that after she complained to leaders, the county removed case files from her computer and blocked her access to them. Magdiar's suit lists only St. Charles County as defendant, while Murray named the county chief Todd and director of administration Lakeham. At the time the lawsuits were filed, Chief Todd had actually retired from the department. The cases proceed through discovery, including depositions, and one was scheduled for trial at the end of 2022 when the county settles with Magdiar's for $450,000. The county settles with Murray in June 2021 for $350,000 plus 8 months of continued pay and benefits when she was on leave, worth more than $50,000. While the county and Chief Todd did not admit fault in the settlement, I think it's fair to say that the county would not be paying $850,000 to settle these cases if they thought Chief Todd would be exonerated at trial. What can we learn from these cases? It can be very expensive to defend sexual harassment cases. At the end of the day, employers are much better off cutting loose employees who violate your harassment policies. Given that Illinois law mandates annual training, no one who is employed in Illinois can credibly argue that they weren't aware of the law and did not know that their behavior could be offensive. Well, I've said before that some employees may simply be trying to be funny or lighten up the work atmosphere. Judges and juries are increasingly coming down on people who violate Title VII and the Illinois Human Rights Act and hold them liable for such misconduct. So it's always better to act, professionally. That's how you should act professionally in the workplace, and then you don't have to worry about being accused of misconduct. So what are the remedies for violations of the Illinois Human Rights Act? First is a cease and desist order, a cease and desist from any violations of this act. Second is actual damages, paying actual damages for the injury or loss suffered by the complainant. Such damages include costs associated with the job search or medical expenses and compensation for any emotional harm such as mental anguish, inconvenience, or loss of enjoyment of life. The third type of remedy is hiring, reinstatement, promotion, back pay, or fringe benefits. Typically, you can get back pay. It's very unusual for a court to reinstate you or to have you hired if you were denied a job. That typically doesn't happen, but it's possible. And then the last is attorney fees and costs. Okay, next scenario. Mariko's coworker John has just been through a divorce. He drops comments on a few occasions that he's lonely and needs to find a new girlfriend. Mariko and John have been friendly in the past and have had lunch together in local restaurants on many occasions. John asks Mariko to go on a date with him, dinner and a movie. Mariko likes John and agrees to go out with him. She enjoys her date with John, but decides that a relationship is not a good idea. She thanks John for a nice time, but explains that she does not want to have a relationship with him. John waits 2 weeks and then starts pressuring Mariko for more dates. She refuses, but John does not stop. He keeps asking her to go out with him. When John first asked Mariko out on a date, was that sexual harassment? No. Even if Mariko had turned John down for the first date, John had done nothing wrong by asking for a date and by making occasional comments that are not sexually explicit about his personal life. True or false? Mariko can't complain about sexual harassment by John because she went on a date with him. False. Being friendly, going out on a date, or even having a prior relationship with a coworker does not mean that a coworker has a right to behave as John did towards Mariko. She has to continue working with John, and he must respect her wishes and not engage in behavior that now has become inappropriate in the workplace. Now, Mariko complains to her supervisor, and the supervisor, as required, reports her complaint to the person designated by the employer to receive those types of complaints. John's interviewed, questioned about his behavior, and he apologizes. He's instructed by the designated person to stop. John stops for a while, but then he starts leaving little gifts for Mariko on her desk with accompanying love notes. The love notes are not overtly offensive, but John's behavior is starting to make Mariko nervous, and she's afraid he may start stalking her. True or false? John's subsequent behavior with gifts and love notes is not sexual harassment because he has stopped asking Mariko for dates as instructed. He's just being nice to Mariko because he likes her. False. Mariko should report John's behavior. She's entitled to have effective assistance in getting John to stop his inappropriate workplace behavior. Because John has returned to pestering Mariko after being told to stop, he could be subject to serious disciplinary action for his behavior. Next example. Inez works as a licensed heavy equipment operator. Some of her male coworkers think it's fun to tease her. Inez often hears comments like, "Watch out, here she comes, that crazy woman driver," in a joking manner. And also, someone keeps putting a handmade sign on the only porta potty at the worksite that says "men only." Question number 1. Women in traditionally male jobs should expect teasing and should not take the joking comments too seriously. False. Whether Inez is being harassed depends in part on Inez's opinion of the situation. That is, whether she finds the behavior to be offensive. However, if at any point Inez does feel harassed, she's entitled to complain of the behavior and have it stopped, regardless of whether and for how long she has endured the behavior without complaint. Inez can always say when enough is enough. Unwelcome and continued teasing subjects Inez to inferior terms, conditions, or privileges of employment and cannot be considered petty or trivial. Question number 2. Inez cannot complain because the site supervisor sometimes joins in with the joking behavior, so she has nowhere to go. Is that true? False. Inez can still complain to the supervisor, who is then on notice that the behavior bothers Inez and must be stopped. The supervisor's failure to take Inez's complaint seriously constitutes serious misconduct on his or her part. Inez can also complain directly to the person designated by her employer to receive complaints, either instead of going to the supervisor or after doing so. The employer is responsible for assuring that all employees are aware of its anti-harassment policies and procedures. Some of Inez's other coworkers are strongly opposed to her presence in a traditionally all-male work environment or profession. These coworkers have sometimes said things to her like, "You're taking a job away from a man who deserves it. You should be home with your kids. And what kind of mother are you?" Also, someone scratched the word bitch in Inez's toolbox. True or false? These behaviors, while rude, are not sexual harassment because they are not sexual in nature. False. The behaviors are directed at her because she's a woman and appear to be intended to intimidate her and cause her to quit her job. While not sexual in nature, this harassment is because of her sex and creates a hostile work environment. Inez complains about the jokes and other behaviors, and an investigation is conducted. It cannot be determined who defaced Inez's toolbox. Her coworkers are told to stop their behavior or face disciplinary charges. The supervisor speaks with Inez and tells her to come to him immediately if she has any further problems. Inez then finds that someone has urinated in her toolbox. True or false? There is nothing Inez can do because she can't prove who vandalized her toolbox. False. Inez should speak to her supervisor immediately or contact any other person designated by her employer to receive complaints directly. Although the situation has become very difficult, it's the employer's responsibility to support Inez and seek a solution. An appropriate investigation must be promptly undertaken and appropriate remedial action must follow. Okay, next example. Mr. T works as a clerk typist for a large employer. He likes to wear jewelry and his attire frequently includes earrings and necklaces. His boss, Sally, thinks it's weird that as a man, Mr. T wears jewelry and wants to be a clerical worker. She frequently makes sarcastic comments to him about his appearance and refers to him jokingly as her office boy. Mr. T, who hopes to develop his career in the area of customer relations, applies for an open promotional position that would involve working in a front desk area where he would interact with the public. Sally tells Mr. T that if he wants that job, he had better look more normal or else wait for a promotion to mailroom supervisor. Question number 1, true or false? Mr. T's boss is correct to tell him wearing jewelry is inappropriate for customer service positions. False. Mr. T's jewelry is only an issue because Sally considered it unusual for a man to wear such jewelry. Therefore, her comments to Mr. T constitute sex stereotyping. Sally is also suspicious that Mr. T is gay, which she says she doesn't mind, but she thinks Mr. T is secretive. She starts asking him questions about his private life, such as, are you married? Do you have a partner? Do you have kids? Mr. T tries to respond politely no to her questions, but is becoming annoyed. Sally starts gossiping with Mr. T's coworkers about his supposed sexual orientation. Question 2, true or false? Mr. T is the recipient of harassment on the basis of sex and sexual orientation. True. Mr. T is harassed on the basis of sex because he's being harassed for failure to adhere to Sally's sex stereotypes. Mr. T is also harassed on the basis of his perceived sexual orientation. It does not matter whether or not Mr. T is a gay man in order for him to have a claim of sexual orientation discrimination or harassment. Is it even necessary to know the sexual orientation of your coworkers to do your job? No. I mean, if your coworkers don't want to disclose it or discuss it, it's none of your business. So move on. Clearly, it's not professional for people to be gossiping about him, and by doing so, it makes the workplace uncomfortable for some. Now, let's say Mr. T complains to Human Resources about Sally. HR investigates and advises Sally that she cannot treat Mr. T in this manner. Sally then decides to not recommend Mr. T for promotion because she's upset that he got her in trouble. Question 3, is Sally's action legal? No. Both state and federal law make it illegal to retaliate against someone because they complained of discrimination or harassment. If Sally doesn't recommend Mr. T because he was not the most competent or the best employee, that's okay, that's legal. But if she didn't recommend him in retaliation for his complaint, that would be a violation of law. Now, occasionally I'll get calls from employees who attend this training wanting to discuss problems they're having with their employer. Because I'm hired by your employer to conduct this training, it would be a conflict of interest for me or unethical for me to help you, but you can always try to find an employment attorney who represents employees to discuss your concerns. Alternatively, you can always get more information from the Illinois Department of Human Rights or the United States Equal Employment Opportunity Commission for free. Now, the Illinois Department of Human Rights has a website that I've posted here. It's intended to help you find appropriate ways to report sexual harassment and discrimination and obtain referrals to legal and counseling assistance resources. For immediate assistance with sexual harassment and discrimination in Illinois, Monday through Friday from 8:30 a.m. to 5 p.m., you can call the helpline, which the number I've posted there. The other option is to call the EEOC hotline, which number I've given you, or you can go to their website and you can discuss your situation. A representative will ask you for some basic information to determine if your situation is covered by the laws that they enforce and explain how to file a charge. So we are now completed. This is the end of your annual sexual harassment training. I hope you enjoyed it, and we will see you next year. Thank you very much.